You're still talking over me.
Well, you're cutting me off.
When I talk, you stop. Understood?
No, I actually don't understand that, Judge.
Why don't you come down here, and I'll make it clear to you. Come down. I'll see you at 12 o'clock.
I'm not coming at 12 o'clock, Judge.
Don't come then and see what happens.
So do you want Attorney Davenport, who is the attorney on this case? Do you want to speak to him? Because if you're asking me,
why are you even talking to me if you're not on this case? I don't even want to talk to you then.
Well, you asked a question about me, Judge, so I started
speaking. You're talking to me if you're not involved in this case.
Well, I am involved. I'm co-counsel on this case, Judge, but just to be...
I want you to come down here at 12 o'clock today.
I won't be coming, but he's Attorney Davenport.
And I'll hold you in contempt of court.
And I'll go ahead and file a grievance.
Do it.
I will.
I don't appreciate any yelling. I feel like it's unprofessional. I feel like she was trying to express the fact that this...
And I asked her not to talk over me, Mr. Davenport. Just like you stopped when I started talking, I expect the same from her.
Just as this happens in other cases, we expect discovery in a timely fashion so we can represent our clients in the best way possible. So as these cases become moot points of discovery, we would like to be able to have a situation where if the complaining witness does show up, we don't have to wait till the last minute. We can either hold the exam or not. We started off asking for discovery in court. We were told we have to submit a discovery order. We started submitting discovery orders. After we submitted discovery orders, we were told we have to keep in communication to remind prosecutors that we have to get our discovery as they're obligated to provide us with. After that, you told us if we were in communication, then we should file motions to compel. We keep trying to do and be proactive, and we're trying to explain this problem right now, but there's no reason.
Mr. Davenport, the witness was to show up. There's no way I would make you go forward on the case that you just received discovery on today, period. Let me talk about what I don't appreciate. I don't appreciate being talked over. I don't appreciate when I'm trying to make something clear. Ms. Davenport indicates that she didn't understand. I told her to come down here. She told me what she's not going to do. I ordered her to do so. So understand that grievance process works both ways. I can file a grievance as well.
And so in this situation where she's trying to get the case dismissed before 12 o'clock because we wouldn't be holding it whether the complaining witness shows up or not, and we're trying to be efficient with our resources.
I'm not inclined to grant a dismissal when discovery was given to you, although it was not given to you timely. I'm not inclined to dismiss based on that.
What would be the remedy for future reference?
What future reference? What are you talking about?
So in any other case, in a situation where we submit a discovery order, keep in contact with the prosecutor, submit a motion to compel, and
I
discovery...
take case by basis, sir. I can't tell you what I'm going to do in the future.
Oh, okay.
I don't know how to comply.
So we just have to keep...
You're not going to comply anyway, Ms. Davenport.
I'm sorry, Judge.
You told me you're not going to comply with the court's order. I ordered you to be here at 12 o'clock. You told me you're not doing it.
Judge, I can't come down there at 12 o'clock today, but when you see me on another hearing, or if you want me to come down on a different time, then we can definitely discuss it. In fact, I know that, is this recorded? Because if this is recorded, then we both can use it in our grievance. But Judge, you asked me a question. I started answering. You cut me off, and then you said, when you start talking, I stop. I'm not a child. I'm not a puppet. I don't disrespect, and I expect to be respected as well.
I expect you to respect this court.
I do respect this court, which is why when you ask a question, Judge, I stepped in to answer your question. I don't like to talk over people either, Judge. It's just that when you ask me a question and then I'm answering it, when you're cutting me off, how do I know if I'm answering your question? When am I supposed to stop or not? If you want to speak, then I will be quiet so that you can speak. And then when you ask me a question, I'll answer your question. I'm sorry, you want to speak to Attorney Davenport.
Ultimately, Judge, in this situation, which was a similar situation as last week, and I understand it's unpredictable and we can't really determine what you'll do based off past action. But last week, when the complaining witness didn't show up and the discovery issue was moot on a different issue, I appeared in court physically. Now, that wasn't a requirement for the prosecution as they came in on Zoom, and I have no problem with that because it's an efficient use of resources. However, I don't agree that it's an efficient use of everybody's resources if we're not going to hold this exam to have us continue to come show up in person. We're doing all this back work trying to make sure we're prepared. So we prefer to appear on Zoom.
I don't have an issue with that.
Thank you.
The prosecution is indicating that the witness is not going to appear.
Very well, Judge. Would you like us to appear at noon?
That's what time the exam is scheduled.
That's true.
Yeah, I want you to address discovery issues in advance no more.
Work for the next case. So we will appear back on Zoom at noon for the dismissal, and I'll see you then, Judge. Is there any other issues you'd like to take care of?
No.
Okay.